right. So it's 12 o'clock. I'll get started. Thank you so very much for joining us in today's EMA session. My name is Vishal Sharma. I'm your moderator today, and I'm joined by Prashanthi Reddy. A quick introduction on Prashanthi. Prashanthi comes from a detailed and distinguished background. She is alumni of University of Pennsylvania Law School from the batch of 1996. She has been in the immigration field since 1997. She's been admitted to the bar in New York. She's currently a member of the American Immigration Lawyers Association and the New York Bar Association as well. She currently holds the position of Immigration Chair for the National South Asian Bar Association and Immigration Co-Chair for the Federation of Indian Associations. She's currently actively involved in pro bono legal work as well. And just to talk about today's format, this is an Ask Me Anything session. So for the entirety of today's session, you will have the opportunity to ask us questions, ask Shanti all your questions immigration related. We will pick them up one by one. Should we not have enough time to answer any of your questions, do not worry. You can always reach out to us via email and we would be happy to take this offline. So on that note, I would invite Prashanthi. Prashanthi, over to you.
Thanks, Vishal. Thank you everyone for joining us. This is a Q&A session, so please have all your questions ready. Vishal, I guess you want the questions typed or?
Yes, please. Everyone, you have your questions. We have the chat option open. So please type in all your questions on chat and we will pick them one by one.
So having said that, let's start with a brief update on what's been happening last month and this month in immigration. Just a few pointers because I don't want to take up too much of the time away from the Ask Me Anything session. So we also have a lot of questions that we received online via LinkedIn, Facebook, etc. So we have quite a few questions that we're going to go through, and of course the live questions. So without further ado, let's start first with USCIS just announced that they'll be launching an online rescheduling of biometrics appointments. So if anyone is required to go for a biometrics appointment, and that could be if you're on F1, H4, filing a B2 extension, or of course, if you're filing a green card, there are many instances where you might need to go for biometrics, which is basically you go to an office and they take your photograph and fingerprints, and then they do a security check. So that's the biometrics. So as of June 28th, USCIS launched a new self-service tool allowing people to and their attorneys to reschedule biometric services online. So this has to be done before the date of the appointment, of course, but you don't have to. Even previously you could do it, but you'd have to call in a number and then do it that way. Now you can just do it online by going to your portal or creating a portal for yourself. So that's, USCIS has been trying to automate, has been doing things online a lot. There's some forms that can be submitted online. There's still a lot for them to do. They haven't even touched the tip of the iceberg, but it's a start. So they're starting to offer some services online. Next, quite important, but not as important as it could be, is that USCIS has provided further guidance on, as of June 14th, on employment authorization documents based on compelling circumstances. So USCIS allows employment authorization for a person who has an I-140 approved and whose visa number is not yet available. So they've had this before, but now I guess not many people are using it because it's not clear as to who is eligible and who isn't. So recently they have given some explanation as to what under what compelling circumstances or under what circumstances a person can actually file an EAD. So for an applicant to be eligible for an initial EAD based on compelling circumstances, first of all, they must have an approved I-140, either the first, second, or third employment-based category. The principal applicant has to be on an E3, a H1, H1B, O1, L1 non-immigrant status when they file the EAD, or they could be in the authorized grace period. For example, the 60 days grace period, once sometimes if a H1B loses a job, they have 60 days grace period to find another job. So that's the 60 days grace period. So you can be in that period also when you're filing for your EAD under compelling circumstances. Also, the applicant should not have filed a 485. Immigrant visa number should not yet be available for the applicant. They have to provide biometrics. They have to have not been convicted of a felony or a misdemeanor. And then, of course, most importantly, USCIS will then determine as a matter of discretion whether the applicant demonstrates compelling circumstances or not. So the guidance with reference to what covers compelling circumstances, it's a non-existent list of situations. So it doesn't have to be list 1, 2, 3, but they've given some suggestions as to what could possibly be compelling circumstances. So serious illness. This is basically, I mean, obviously for people who have lost their job, because if you already have a job, you would be on a H1. So this is when you cannot be on a H1 or L1 or one of those other situations because of some compelling reason. Then you can apply for this EAD, and you can work for any employer then. So this compelling circumstances includes a serious illness, a disability, maybe an employer dispute or retaliation by the employer because of which you've lost your H1. Other substantial harm to the applicant, significant disruption to the employer could be a reason. The guidance also provides details on evidence that the applicant can submit. For example, if the principal applicant is saying that the compelling circumstances, the fact that they've lived here for many, many years, they could submit evidence that they went to school here, maybe went to high school here, so all the enrollment records. If they're saying that they have some financial difficulty, meaning that they can't pay their mortgage, then you could submit mortgage documents, etc., etc. So if, say, they'll have to pull their kids out of school because they can't afford the tuition, you can submit evidence of that. So this is all the evidence that you can submit for cases under compelling circumstances. This is great, especially for non-migrant workers who have been laid off. This will benefit them because then they can, if they're able to get an EAD, then they can work for any employer. But it's still very narrow in scope, mainly because first thing is that we don't know which cases that the USCIS will approve and which cases they won't. It's really seems to be quite subjective. It depends on the officer. Also, it takes a long period of time. So if there's no premium processing for this kind of EAD, so it could take several months. So you might be left without a job, without work for several months because you can't work on a pending EAD. Also, this type of EAD doesn't confer an actual non-immigrant status on the applicant. It only allows you to live and work here. It's intended as a stopgap, and it's allows you to, it's considered to be a period of authorized stay, not an actual non-immigrant status. So you won't accrue an unlawful presence, so that's a good thing. But you're not provided with any path to green card. You can't file a green card while you're in the country. So you can't file adjustment of status. You can't file a change of status to a H1. So you'd have to leave the country, get a H1, get a visa, and come back in if you want to get back onto H1. And also, it's each time you have to extend your EAD. This might take again several months, and you might find yourself without being able to work because your EAD is still pending. So they're definitely, I mean, it's good for a person who's desperate and has no other um, means to stay in the country and work, but it's not ideal. It's not an ideal status to be in for those many reasons that I just mentioned. Going to the next topic, USCIS expands premium processing as of June 12th. They expanded premium processing for applicants seeking a change of status to an F, M, or J non-immigrant status. This is great for people who are filing for a change of status to an F1 status, to a student status. Previously, it was an issue of being able to file a change of status because change of statuses were taking 10 months or more. And, it's difficult to stay in status for that long. I mean, it's difficult because your school will start at some point and you won't be able to join school. So to time that, the start of classes versus USCIS approval of the case was very difficult. So even if you got an approval, it would be useless because of the time taken. So that's very important that they started premium processing for these kind of cases. So you can actually, with more certainty, enroll in a school and, start classes on time. Another interesting development as of June 29th, very recent, is for H-1B holders. It's not US immigration, but it applies to people who are on a H1. So that's why I thought I'll mention it. Canada announces a new program for H1B, for holders of a H1B visa. They're giving them pretty much an open work authorization. So if you have a valid H1B visa, you could go to Canada and apply for the Canadian work permit, and you could work for any employer. So please remember this. This is being done by Canada, obviously, to attract high-skilled workers who are in the US. They also give work authorization to dependents. So this could be attractive for some people that maybe prefer to work in Canada if there are opportunities because they can work for any employer. And the dependents can work as well. And there are not that many restrictions. So, it's a great way for Canada to, get the high-skilled workers from the US. The only thing is that it says that they have to have a H-1B visa. It doesn't say H-1B status. So I'm presuming it's not enough if you have a H-1B I-94, but you have to actually have a visa. So if you don't have a visa stamped in your passport, you may not be eligible for this work authorization. That's all I have, Vishal. We can now go to the AMA session.
Sure. So I already see a lot of questions coming in, and just a reminder for everyone who wants to ask your question, we have the chat box open. Please drop your question there. So I'll get started with the first one, and please bear with me, Prashanthi. It's a long one. I guess you can read as well, but I'll just read it slowly here for everyone's understanding. I work in company A, but I applied for H-1B visa through company B. My H-1B visa got approved and stamping done in December 22, but I have not traveled to the US. My potential employer called and told me that my I-123 is revoked. When I check in the USCIS website, I see this message, and then the message. Do you want me to read the message here?
No, it just says we revoke the H-1B approval.
Yeah.
Yeah. And mail you a revocation. Please follow
Yeah.
instructions, blah, blah.
So is this case, in this case, can I transfer my H1B? What can I do from my end?
So the question is also, even though the employer says he received the notice, he does not plan to file an appeal, fine.
Mhm.
I applied H1 only through company B. There are no multiple applications. And also employer is not sharing all the information of the revocation notice as to why it was revoked, I guess. In this case, can I transfer my H1B? What can I do from my end? So it looks like that he works in company A but applied H1 through company B, and the H1 got approved and stamping done. So I'm not sure when he says I work in company A, whether he has a H1 through company A or doesn't. I don't know. But and if this is counselor processing or not, it looks like it's counselor processing. So there's some more answers that we need here, some more information before we can further answer this case. But say he already is, let's just presume that he's working for company A and he has a H1 and he's filing for a H1 transfer with company B. I think that's the case. Obviously, then I don't see what the point of the question is, Ananta, because it looks like the transfer has been denied. So obviously, then you cannot work with company B. You have to continue working with company A if you have a H1 with them. As to why it was denied, it could be that the company B filed several, filed multiple registrations. I don't know if this is a cap case or not. Again, it's not clear. Maybe it is. Ananta, if you can just give us more information, we'll get back to you.
Yes.
So that we can better answer your case and not speculate.
Yeah. And this is one of those cases, I think we need more information, and B, there is very specific information ascertain to this particular individual. So, Ananta, if you would like, feel free to reach out to us and we'd be happy to take this offline. Or if you can just share more information over the chat, we'd be happy to look into it as well.
Right. So
For
if
the
it is,
time.
Vishal, just again, if it is a cap case and the person is currently in India, then there's not much that they can do. I'm just, giving all the scenarios. There's not much
Yes.
that the person can do. You'll have to wait unless you're not cap subject. You'll have to wait until next cap season and then file your H1 then. It looks like your H1 was already approved. So you may not be subject to the cap. So it's possible that you could file a H1 through another employer. But the thing is that if the H1B has been withdrawn, which looks like it has been withdrawn, then in that case you are cap, you're not cap exempt. So you'll have to file under the lottery again next year. You would only be cap exempt if your H1 was not withdrawn. Or actually revoked, it looks like. If it was withdrawn, it would have been fine, but it looks like it was revoked by USCIS. So if it was revoked, then it's most likely that you will not be eligible for cap exempt status. So you'll have to file under the cap next year again, file for registration and then file. I think that should answer the question.
Okay. Thank you.
Please please be specific as to what is your present status, where you are, and then ask your question. Thanks.
That'd be helpful, certainly. All right, I'll move to the next one. My daughter is a US citizen, born in the US. We are currently in Canada. My daughter is now 21 and up, and she is finishing her graduation from Canada next year. Being in Canada, can she file our green card in the US? Me and my wife are Canadian citizen. I would appreciate if you let us know.
Yeah, that's great. So yes, she can, but she has to establish residency in the US. So she should come to the US, stay here for 6 months. There's also the matter of who's going to be financially responsible. if she hasn't started working as yet. So you need to get another person to file the affidavit of support along with your daughter, someone who's working and who can afford to support the two of you. Also, just an FYI, it's easier to get a green card while you're in the US. Rather than if you're outside the country, it takes longer because then it's a different process. You have to file consular processing. And most consulates are backed up, but it is certainly an option. You could file while you're outside the country as well. So the main thing to keep in mind is you can file, but she needs to be in the country, established residence, and you need to find a co-sponsor to sign off on the affidavit of support.
There you go. That's the answer. Before I move on to the next question, a gentle reminder for everyone. Chat box is open. If you have questions, please ask your questions there and we'll pick it up. Thank you. Next is, I have had U visa since 2019. My 3-year limit is finished on December 22. I have applied for the renewal of our work permit and the green card application. Our application was submitted to USCIS on 24th May 23. Fee check has been debited from my account and is clear, but I have not received receipt notice from USCIS. I would like to know what is to be done for that, and normally how much time will USCIS take to approve work permit and GC?
So I like the questions because they're very diverse. So that's great. So basically, with reference to not receiving a receipt, that sometimes does happen. They will mail it out and you may not receive it or whatever. The post office is horrible since COVID. So it's possible that you didn't receive the notice. But if your check has been cashed, that obviously means that they have started working on your case. And also another tip is that on your check, if you have your cash check, or you can get it from the bank or from your online statement, the back of the check should have the receipt number. So all you need is to have the receipt number so you can enter it into the USCIS website to then find out, what is your status. They don't usually issue duplicate receipts, so that might not happen even if you ask for it, but you certainly could by contacting Emma on the USCIS website. Also, how long will it take? If your date is current, then maybe 18 months or so to get the green card. And the EAD is really taking, USCIS is not being uniform on processing of the EAD. So in some cases, it's taking family-based cases I'm talking about. It's taking about 3 to 4 months, sometimes just 2 months, and sometimes it's taking over 6 months, 6 to 8 months. So it's difficult to predict how long your case will take, but in between 2 to 6 months, I would say is the processing time for the EAD. But just keep in mind that it's not the same for everyone. It's not uniform.
Okay, great. I'll move to the next one. The next one, there are a few messages, so I'll have to go through each of them here. Bear with me for a moment. Regarding H4 EAD, my spouse I-94 extension is placed, but H4 EAD is valid until next year, October 24. I-94 was shortened just because of passport expiry. In case she has to go out of US as she has a valid stamped visa with the H1B from previous employer, but now H1 changed company, so primary has valid I-797, but H4 doesn't have valid I-797. Can she travel to US with primary H1B approved I-797? Note visa stamp is with different company, and now primary I-797 US with different company.
Yeah, so basically what she's saying is that the spouse, his spouse, is on a H4. I guess I-94 extension is placed. What does that mean? Maybe it's been filed. H4 is obviously the H4 I-94 and the EAD is not the same date. Maybe it was done at different times. So the EAD is valid until 2024. I-94 is not valid because for the same date, I think, because when she entered, her passport was expiring, so they gave it only until the expiry of the passport. So she went ahead and applied for the extension. Now he's asking if she goes out of the US with the previous H1B employer, but now H1 changed, so primary has a valid, but the H4 doesn't have valid. Travel to US, visa stamping is different company. Yeah, so the question is not clear. I understood all the facts, but I think the only question they have is that if since her I-94 is expiring and the EAD is still valid, and obviously they can't use the EAD unless the H4 is valid, so they want to leave the country and come back on a fresh I-94, which is a great idea. And I don't see any issues with it simply because the person is worried that since his employer has changed, does that make any difference for her H4? No, she can leave the country. If she has visa stamping, doesn't matter which company she has the visa stamping through or which company he has the visa stamping through. She can leave the country and come in on a fresh I-94 based on her spouse's H1B approval, and she will get the same period of time that the spouse has on his present I-797 approval. And she doesn't have to go to the consulate either because looks like her visa is still valid. She can use that to come in and get a fresh period on her I-94 and then continue working on her EAD. So that's, they have a plan.
Okay. I think there was one more question there. Can she keep working until H4 I-94 approval?
That makes sense now because I think it's all in different parts. So.
Yes.
I would suggest that she not work until her either her I-94 has been extended or she leaves the country and comes in with a new I-94 period. Simply because the EAD is based on H4 status. If there is no H4 status, then there is no basis for H4 EAD. So I suggest that she doesn't.
Okay, that was a long old question, but hopefully you were able to answer. I'll move to the next one. Perm PWD validity is 1/13/23 to 6/30/23. First recruitment started on April 5th, 23. In this case, we have to file ETA 9089 with in the PWD validity period, or can we file ETA 9089 after the expiry of PWD 180 days from the date of first recruitment?
So if the perm is, so there are two different questions that they're asking in the same thing. So one is validity of the prevailing wage, and the other is validity of their recruitment. So just for those other listeners who, this is pretty complicated stuff. So just to simplify it for everyone, when you file a green card, you have to file something called a prevailing wage, and the prevailing wage has a validity. In this case, the validity is from between January and June of this year. So you're supposed to start. You're supposed to either file the green card before the prevailing wage expires, or you have to place the advertisements while the prevailing wage is still valid, between the validity of January and June. So in this case, since they have placed the ads while the prevailing wage was valid, they didn't do the ads before the prevailing wage came. Some people do that, in which case then they will have to file the perm while the prevailing wage is still valid before it expires, before June 30, which it has already expired. But since they started recruitment during the validity of the prevailing wage, which means that after it got approved and before it expired, the expiry of the prevailing wage no longer matters. They can go ahead and file the perm even after expiry of the prevailing wage because they have done the ads while the prevailing wage was valid. But you always have to do the perm while your ads are still valid. So that's a different deadline from the prevailing wage. So just to make that clear, you place all the ads, you have to wait for a period of 30 days, and then you have to file the ads, and the ads become stale after a period of 180 days. So before 180 days, you have to file all your green card cases. You have to file that employment-based cases. So the duration to file your perm is after 30 days of recruitment and before 6 months. So after 6 months, the ads expire. So you have to do it before 6 months. But yes, you can definitely go ahead and file your labor cert after the expiry of the prevailing wage. I hope that's clear.
That's very clear. Thank you. Next question is, as of now, I am in F1 STEM OPT visa status. University said I can work for 2 full-time jobs at the same time in STEM OPT. My question is, do I face any issues with immigration if I work for 2 full-time jobs?
I don't think there's any restriction with reference to OPT on the maximum number of hours. There is regulation with reference to minimum number of hours that you have to work. But there's no limit on the maximum number of hours that you can work. It just has to be humanly possible for you to work that amount of time. So I don't think there's any issue with you doing 2 jobs.
Okay, hope that answers. I'll move to the next one. I have attended visa interview for H-1B first on February 1st, 23 from London. VO took most of the document and given 221G white slip. After that, on May 15, 23, I received an email from London Visa Office. They have sent back my petition to USCIS as the request for revocation is based on further administrative review subsequent to your visa interview at Embassy London. Can you please suggest me, can I apply another petition from other employer? Any suggestion would be helpful.
Yes, so it would be helpful to know why the visa was not granted. And, usually when the visa is not granted because of some issue with the employer, they send the case back to USCIS, recommending that USCIS revokes the H1. So what happens is then USCIS, once they receive the correspondence from the Department of State, they will send a letter, notice of intent to revoke NOIR to the employer, giving them 30 days as to why, giving them an opportunity to respond within 30 days as to why they should not revoke the H1 and giving them reasons as to, USCIS will give reasons as to why they are revoking it. So the employer has a chance to basically tell the USCIS or respond to what the USCIS is saying and why they should not revoke that petition. They can dispute whatever information that the USCIS has. So if this is not something to do with you, then you're definitely able to file, and it should not have a black mark on you if this is employer related. So you should be able to go ahead and file another visa application by applying for a H1 through another employer.
Okay, I think there was a continuation to this question. My spouse also attended H-1B with same employer on December 22nd. She also got 221G white slip. After that, she got an email to submit contractual relationship between client and employer. We replied in February 23. Employer got verification email in March 23. And they replied next day, no updates later.
So she's just giving us some facts. He didn't really ask a question there.
Yeah, that's
but
more
he's just
facts.
telling us what happened. It looks like both of them filed through the same employer. Maybe some issues with the employer. I'm surprised that the consulate is asking for information on employer-employee relationship. I don't know. They're asking for a relationship between the client and the company. So maybe they're doubting the job offer. Maybe there is some, I mean, maybe they're doubting whether or not a job exists or not, because there seems to be some question you said with reference to relationship between the client and the employer, correct?
Yes.
So maybe they're doubting the job offer itself. Something going on there with the company. So, difficult to know what to expect. But good luck on your wife's visa application as well.
Okay. Before I go to the next question, we've just reached, well, we are slightly beyond the halfway mark. So this is another gentle reminder. I'm assuming that if you are joining today's call, you probably have a question, so you can put in your question in the chat box and we'd be happy to take it from there. That being said, I'll move to the next question. Can we apply for H1 extension with perm approval if H1B 6 years is completing and perm applied and pending 240 days? Or do we need to wait for I-140 approval as well? Currently, perm approval taking around 270 to 300. Do you see any change in these timelines for perm approval?
So I guess two questions. This person's H1B 6 years is expiring. They filed the perm and it's pending. Looks like pending for 240 days. So you can, as of the date that your H1 is going to expire, your perm or I-140 should have been pending, or perm plus I-140 should have been pending for 365 days. If that happens, 365 days or 1 year, then you can file for a H1B extension for 1 year. Now, if your I-140 gets approved while you're before your H1 expires, then you can actually file for a H1 extension for 6 years. Sorry, you can apply for a H1 extension for 3 years. Sorry, never for 6 years, 3 years at a time. So that's the difference. So 365 days pending, you can apply for 1 year. If your I-140 is approved, you can apply for a total of 3 years, and you can continue applying for extensions in 3-year increments.
Okay. I see that there was more information provided on that. I'm just going to quickly read it through, see if there is any question or is it mainly facts. H4 dependence extension was approved, but previous I-94 was valid until 7th Jan 23. And in new H4 extension approval notice received date and I-94 start date is 9th Jan 23. There is 1 day gap, old I-94 end date and new I-94 start date. Will that cause any issue? Extension was applied and sent to USCIS on January 7th.
Okay, so it shouldn't have been sent on January 7th if your I-94 expired on January 7th. It should have been received on January 7th. So there would be a gap of 1 day. And that's why maybe there's a gap of 1 day, because you sent it the day it was expiring. It has to be received by that day. But looks like it was approved. And I don't see an issue with that, because even if you're filing a green card, even if there is unlawful stay period of 1 day, there is something called 245K, under which it allows you, it forgives you being out of status for 6 months and allows you to still adjust your green card. I don't see that being an issue with visas. They don't usually look at that or pay attention to it or care about it as much. Of course, there can always be an issue. You never know when, and even 1 day of out of status is out of status. But in general, they don't usually make that into a big deal. But if that has to be looked at, it would be either at the consulate or when you're filing for your green card, or when you're entering the country at the port of entry. But I really doubt that that's going to be an issue. But just for future reference, you cannot file your case the day it's expiring. It has to be received the day it was expiring. So if the receipt is wrong, then it's fine, as long as you sent it on time.
Okay, hope that answers. Next question is, being in the US, how much time would it take to file the GC?
That's a loaded question, even though it's a short question.
Yeah.
It depends on what kind of GC that you're filing. So it's a very broad question, but I will just answer it very broadly. If it's family-based, then and if your priority date is current, then it can take 12 to 18 months. If your priority date is not current, then you have to wait until it becomes current, and that the dates are different for different family categories. So you have to go and look at the visa bulletin. For employment-based, again, if it's current, same amount of time, 12 to 18 months to get the green card. And if it is not current, then it could take several years, depending on which country or form. India is the most oversubscribed. It's taking, I was just reading an article. They said now, if you file now, it'll take 100 years to get your green card.
Good luck
On
with that.
EB2 and EB3 basis. EB1 is, I think, 1 year. So you'll have to wait for 1 year and then another 1 year processing time. I hope that answers your question.
One of the questions was, what is AC21 job portability?
So basically, AC21 job portability is when you have filed for a green card, you're allowed to change jobs provided that you filed the 485. It's been 6 months since you have filed the 485, and also your I-140 is approved or is going to be approved at that point of time. So that's what AC portability is. It gives you AC21 portability. It gives you opportunity and flexibility to change employers while your 485 is pending. And for a lot of you who don't know, if you're filing your green card based on dates for filing rather than final action date, then it could take several years, and you could have a pending 485 for several years until your date becomes current, because dates are retrogressing rapidly. So that's why they have that in there, so that you have the flexibility of working for other employers. Now, the other thing to remember is, in order to make use of this AC21 flexibility, the job has to be same or similar. So it can't be a completely different job. So just to keep that in mind.
Okay. Prashanthi, the next question, I know that we've had a full-on session on it. The last session was on it, but I think it's a burning topic, so I'm going to ask you, what is H-1B collusion and what is not?
All right, so H-1B collusion is instances in which two or more employers have colluded together and filed the registration for the same beneficiary with the intent of increasing the beneficiary's chances. So, which means that they didn't actually have a job, a separate job for that employee, but they came to an agreement that, whoever gets the registration approved, they'll hire them through the same end client or something like that, some kind of arrangement like that. They'll share the job opportunity with each other. Now, it's not collusion when, and if they have a separate job offer, which means company A has a job offer with American Express, and say company B has a job offer with whatever, Time Warner Cable or something like that. So then it's not collusion. It's also not collusion when the beneficiary is filing through separate employers, and the employers didn't agree with each other, for the filing. They're filing it separately. So even then, it's not collusion. So that's collusion and not collusion. It's very important to know these differences, because there's a lot of confusion on this subject.
Yes, yes, and I do have a continuation on H-1B. This is more of a speculative question, if I can. Will we have a second lottery this year?
It's difficult to say. Really depends. I mean, we should, and that's the consensus that most people are agreeing with, because the registrations have been so many and there have been so many duplicates that for sure the registration numbers have not been used. The H1B cap numbers have not been used as yet. So I think USCIS will have to have a second registration. It can be any time now. We don't know when, until the end of the year. But USCIS is unpredictable, and they might just come up with a story that they've received enough numbers. There's no transparency with reference to this. So, it's hard to say for sure, but the thought process seems to be that there will be a second registration.
Okay. Prashanthi, I'm coming back to one of the live questions that we've received, and then we can go back to some of the offline questions. This one is, I just transferred my SEVIS or SEVIS to another school for day one CPT. If there is another lottery this year and is picked from my previous employer, who is willing to extend an offer letter in order to process H1B, and I withdraw from the MBA program and concurrently apply for B2 visa, would there be any issues? Would it be advisable withdrawing, maybe financially viable, given the tuition fee would be refunded?
So I'm not quite sure why they want to move to. So it looks like what the person is saying is that they've started day one CPT, I guess, because they're studying right now and they applied for a CAP H1, didn't get picked. So they have to, I guess they want to continue working for that employer. So they've applied for they've enrolled in school again for another degree, applied for day one CPT to start working. So the person is asking if there's another lottery, and my previous employer is willing to extend the offer letter in order to file that same H1. Can I then withdraw from my school because he's doing an MBA now, and concurrently apply for B2? But the thing is that if you, excuse me, if you apply for a B2, your B2 has to be valid. You have to be, see, this is the important thing that you have to remember. As of the date of filing the H1, say if you get picked in the lottery and you file, as of the date that you file, you have to be in status until the start date of the H1. So October 1st or later could be the start date. So until October 1st, you have to be in status, whether that be F1 status or B2 status. So you cannot, you could be in pending status, meaning you could have a pending B2, or in this case, that's what is likely to happen, because if you file for a B2, it's not going to be approved for the next 10 months. Processing time is very long for a B2. So you'll most probably be in a pending B2 status, and they may not approve the H1 until you get the response on the B2. It is called a bridging petition, but they want to see that the B2 is approvable or approved before they actually take action on the H1. So they might just send you an RFE asking for an approval, in which case then you will not have any recourse, because you don't have um, any control over when they will approve that B2. So my suggestion is to remain on that F1. It's less complicated, rather than switch to a B2 and then file a H1, and then, change of status. I mean, the worst thing that can happen is then the change of status application from the B2 or from the F1 or whatever it is might get denied. So as long as you maintain status, I mean, the change of status could get denied. So then as long as you maintained your status, you can always go out of the country and apply for a visa and H1 visa, and then come back in as soon as that happens. So that's possible as well. It's just a little messy.
Sense. Just a reminder, we have around about 10 minutes left for the session. So if you still have any questions, please feel free to drop in your questions on the chat box. I'll go back to one of the offline questions, Prashanthi. Laid off before getting green card, I-485 pending. How do I handle this?
So someone was laid off before getting the green card, the 485 is pending. So you're allowed to file for an AC-21 and transfer the employer. So you could do that, but of course it's possible that you may not have an employer to transfer to. So technically at every given point of time, your 485 should be attached to an employer. But again, they're not going to look at it day by day or, week by week. So you could possibly file for, it's tricky, but you could file for the AC-21 as soon as you get a job and then continue your green card that way. If it's not, it could you just needs to be an offer of employment. It doesn't have to be an actual job that's available. It has to be an actual job, but not a job that's immediately available. So as long as it's an offer of employment from an employer and the job is same or similar, you can still maintain your 485 processing.
Okay. I would like to get to the next question. This is for H-1B. What does a specialty occupation mean?
In order to file for a H1, the only person who qualifies for a H1 is those people who have where the job requires a bachelor's degree in a specific field, and the person actually has that qualification. So those are specialty occupation jobs. For example, software engineer, as per the Labor Department, as per their publication, the Occupational Outlook Handbook, which they publish, which is available online for anyone to see. A software engineer job usually requires a bachelor's in computer science. So you see a bachelor's is required, and it's also in a specific major. So it's computer science. It's not just bachelor's any field, or bachelor's in arts, or even a bachelor's in MBA, and not a specific MBA is not a specialty occupation. So in this case, a software engineer position is a specialty occupation. And in addition to that, the person filing the H1 has to have a computer science degree or a degree related to computer science. So that's what a specialty occupation position is.
Okay. We'll probably have the last offline question, and then I'll move on with the presentation. My name was selected in the H-1B 2024 lottery, and it is in the process. While my spouse is pregnant, maybe on October 1st, 6 months will be completed. Is there a problem acquiring an H-4 or with POE or traveling?
Is the person in the country or outside the country? Does it say?
It doesn't say, but maybe we can.
So I think the person is outside the country because it's a cap case. Let's just presume that. And traveling while spouse is pregnant. The airlines might have some rules with reference to traveling. So you have to get a doctor's letter to show that you can travel. But the H4 spouse can really come at any time. Does not have to come with the H1 spouse. So they can come at a later period of time, maybe after they conceive or whatever. But whenever it's safer for them to travel, they don't have to come at the same time as the primary spouse. They can come at a later period of time as well.
Okay. All right, Prashanthi, I will go back to my presentation. Any final comments or thoughts from your end?
No, I think we've covered most of the questions. Even the questions that were asked later were just comments, and I was just going through them. Okay. They didn't seem to be actual questions. They were just giving more information. So I'm hoping that we've covered everyone. If someone is not covered, then as Vishal said, he'll give you instructions to send emails, and we'll try to answer them offline. Absolutely. So on that note, I thank you, Prashanthi,
for taking on the time and answering all these burning questions. For those who are in this call, we would be hosting the next either an AMA session or a webinar very soon. So please be in the lookout on your email and on LinkedIn. We'll be reaching out to you with the new dates. Prashanthi, thank you so very much once again.
Thank you. Thanks, Vishal. Thank you all for being so patient and for coming on the show. Thank you.